Counsel, let me ask you here on the appellee side, more than one argument?
Your Honor, I will handle the argument for all of the appellees.
Okay, so one argument. Okay, that'll be fine. Thank you. We're here from the appellant.
Yes, Your Honor. Matthew Grossman of the Knoxville Bar. I represent the plaintiffs who are the appellants in this matter. Just very briefly to...
You want to reserve any time?
Oh, yes, Your Honor. I appreciate you pointing that out to me. I'll reserve 5 minutes, please.
5 minutes will be fine.
This is a case that involves a dispute over the use of certain real property in a subdivision in Campbell County. At the outset, we are going to talk a lot today about a case out of our Supreme Court called FSD, and I'm not going to refer to the plaintiff because that will be painful for me to do that over and over again. So referring to that case will be FSD. The first thing I'd like to start out saying is, notwithstanding the briefing filed by the appellants, and backing up a little bit, my clients are lot owners in this subdivision who have filed a suit to enjoin, essentially as a nuisance, both under the common law and under recorded restrictive covenants, some short-term rental activities on properties owned by the defendants. Notwithstanding the brief that the appellees, the defendants, have filed, we are not challenging the FSD case in any way, shape, or form. Obviously, that is Supreme Court case law. It's binding on this court. It's obviously binding on the trial court. However, we do believe that notwithstanding the Supreme Court's pronouncement in the FSD case, we essentially raised 3 errors by the trial court, and they all relate to the fact that this case comes before this court on Rule 12. That's noteworthy because FSD came to this court and to the Supreme Court after Rule 56. So what we're dealing with here are strictly the pleadings and a motion and a Rule 12 motion. We're not dealing with any disputed facts. Obviously, this court accepts the facts that we have pled as true for purposes of defending against that motion. So item 1, we believe the trial court erred in applying the FSD case, and I'll develop this a little bit more as we go along, but as we read FSD, the trial court essentially flipped it around. FSD clearly contemplates that a short-term rental of property without more does not per se violate restrictive covenants that have a residential use only or a no commercial use provision in them. But essentially in reviewing the trial court's ruling here, the trial court flipped that around and essentially said, no, FSD essentially blesses per se a short-term rental in the face of these restrictions. We believe that's an error, and we're asking the court to reverse on that ground. Secondly, as far as the nuisance claims, which relate to both the contract issue of the restrictive covenants as well as common law, we believe the trial court erred by, I guess, essentially in addition to finding that the FSD case barred our claim, but also finding that under some common law doctrines relating to the use of real property, landlord-tenant relationships, that in this circumstance with these short-term relationships between hosts and guests, that we couldn't establish as a matter of law for purposes of Rule 12, that the host, the owner of the property, is not in fact causing the nuisance. That's something that we believe, again, requires remand to be fleshed out further. And the third issue involves the, I say, unique construction of the restrictions at issue. As I understand it, we have a multi-phase subdivision, and they each have a different set of restrictions. Section 2 has a slightly different set of restrictions that we believe, as I get to, will cause this court to have to reverse the interpretation of these restrictions as it relates to short-term rentals as to the Section 2 portion only. Again, I won't belabor that this is a Rule 12 case, so we're confined to the pleadings, we're confined to the facts as pled, as we have pled. I think it bears pointing out just some of the language in FSD. says, "We conclude that the residential and no other purposes provision in the 1984 covenants does not clearly prohibit short-term rentals. At best, the provision is ambiguous because any ambiguities in restrictive covenants must be resolved in favor of the property owner and in a manner furthers unrestricted use of the property. We hold the 1984 covenants do not prohibit the owner's short-term rentals." Again, it's a bright line rule, but it's a narrow rule. It basically says, no, you can't attack a short-term rental use merely because of a commercial use prohibition or a residential use only language in the restrictions. It's just.
Okay, but does FSD even apply to the sections 2A and 2B, which specifically allow for home rentals?
Actually, we believe that, I'll jump ahead a little bit to address that. Yes, Your Honor, it frankly doesn't, because in that case, we do have two property owners as defendants who have property in Section 2. In those restrictions, let me bounce ahead. What we have is language that essentially calls any home rental a commercial use. So it's our position with respect to the Section 2 defendants is that the reference in the restrictions to renting your home as a commercial use means that it is that what we have is certain lots in Section 2 have that restriction. Others are allowed to make that commercial use. The lots of these particular defendants do not benefit from the commercial use grace for Section 2, and rather, as to those lots, given that definition of commercial use encompassing a rental, it doesn't matter if it's short-term, long-term, whatever. You can't rent those properties. Have I answered your question, Your Honor?
I think so.
Well, I shudder to think that I may have answered your question.
Are you saying that because that provision specifically talks about commercial use, that it's definitely commercial use and therefore not residential, and therefore the language that talks about renting homes is null?
Well, no. It applies to that language applies to certain lots, saying commercial uses such as renting a home are allowed on these lots in Section 2. By inference, the remainder of the
ones
lots
that don't have that language.
Correct, but you would construe the language consistent with the overarching intent of the restrictions, and they call it a commercial use. So the defendants, and I can tell the court that is, those are we call it the Howard Roberts Courtney property and the Roberts property, are going to be subject to interpretation of these restrictions as though rental is a commercial use, and therefore we believe that takes it outside of the scope of the holding in FSD. And
now let's make sure I understand it. That the restrictions say that some lots can do rental. Well, the restrictions only, as a general matter, the restrictions don't speak to short-term at all. I know. I didn't mean to say short-term, but in Section 2, it says commercial uses are allowed on these certain enumerated lots, which are not lots at issue in this case. Yes, it says may be used for commercial purposes, and then it describes, doesn't it? And correct me if I'm wrong, and I'll ask the appellees the same question. Doesn't commercial purposes, isn't it defined as rentals? Well, that's our interpretation, is that. So here, and that's different from the language in the Supreme Court case, right? Yes, Your Honor. The Supreme Court case doesn't, that case, I believe it just had a residential use only restriction, and there wasn't any definition of what commercial was. Here, at least, restrictions on part of the subdivision, I guess. Yes, Your Honor. You know, and define rental as a commercial purpose. Yes. And so, and that's why we believe, at least as far as those two lots I just described to the court, those defendants don't get the benefit of the I guess we'll call it the anti-per se rule of FSD, that the mere short-term rental doesn't constitute a violation of a residential use restriction.
And I know you've got arguments you want to get to, but just so I understand the big picture. So we have a neighborhood that's got a bunch of houses, some of which can be rented out and some of which can't, depending upon which section of the covenants and restrictions apply.
Yes, and even
how
furthermore.
does that make sense?
That's exactly the case. And furthermore, even in that section where that separate regime applies, it's certain lots it'd be okay, and certain lots where it wouldn't be okay.
Okay.
And I guess if the court would allow me just to knock off a couple minutes of my rebuttal, just to kind of hit a couple points, if that'd be okay.
Sure.
Okay, thank you very much.
So what, you asked for 5?
I asked for 5. I guess I'll
Now
go
we
with
have
3.
3 minutes for, he will have 3 minutes for rebuttal.
Again, we have a couple issues. So I think I've kind of covered how the FSG interplays. So the next issue we have here involves this, we'll call it tenant-caused nuisance issue. We take issue with that for a couple reasons. Again, we're on Rule 12 here, and it bears repeating what we've pled. And what we've pled is guests who stay at the property on a short-term basis do not use the property as a residence. Instead, such guests use the property as a vacationer would use a hotel or commercial resort. Guests who routinely stay at the property on a short-term basis often host late-night parties, blare loud music at unreasonably loud levels and at unreasonable hours, and/or engage in other unreasonable behaviors that constitute a nuisance to the residential neighborhood. Again, we believe that this states a claim to certainly go beyond the narrow but bright line rule of FSD, and requires the trial court to flesh out the facts here, be it at summary judgment or at trial, but not on Rule 12 based upon these pleadings, which are substantially identical as to each of these different parties. One other thing I would point...
Is that allegation a blanket allegation as to all homes that are being used as rentals, or is it a specific allegation as to specific homes at specific times?
It's blanket in that we generally say this regularly occurs. It is specific because we are only pointing to the lots of these defendants as being the source of nuisances.
Okay.
Again, one thing I think is really important to point out is we have the case of that's actually cited in the defendant's brief, which is Terminal Co. v. Jacobs, which is in 2002 Tennessee Supreme Court case. It's at 72 Southwest 954 at 956. And I think it's worth pointing this out, and then I'll have a seat. What has been said may be repeated here. If the property at issue was a nuisance at the time of the lease, then the landlord, by his contract of leasing, could not have avoided liability. But inasmuch as it was not then a nuisance and only became a nuisance upon use by its tenant, we think that the liability of the landlord would depend on the fact to be passed on by the jury under proper instructions. So what we have is the trial court, unfortunately, I think put the cart before the horse, said, well, and really didn't evaluate that we have stated facts that could get us in a position where a reasonable trier of fact could make that finding. And looks like I've run over, and so I'll sit down.
That's fine. You have your 3 minutes for rebuttal.
Thank you very much, Your Honor.
Hear from the appellee.
Thank you, Your Honor. Erica Barnes at the Nashville Bar on behalf of my clients, Nick Galbraith, Megan Galbraith, and Edward Bayer, and I will also be arguing on behalf of all of the other appellees collectively so that we have a common voice today. We can agree on one thing, and that is that FSD is the binding precedent on the trial court, on this court, and on all of the parties to this case. And FSD's language makes clear that unless the covenants specifically prohibit a certain activity, then the real estate should be allowed to be used to the best of its ability. And in this case, the language in FSD found that the residential use only language did not prohibit short-term rentals.
Well, but doesn't the restrictive language here have more or some different things in it than was in the Supreme Court opinion?
So as far as, I would like to address the 3 different sections of the property. The Code Norris section and the Tract 3 section, the language is nearly identical to FSD, with the exception that there is no time limitation. Ultimately, There is no time limitation in any of the covenants at issue before the court today. So essentially, the first section and the third section do not contain this commercial use language that the appellant's counsel was addressing with the court. And so because of that, it only contains the residential use only provision like FSD. And because FSD instructs us that unless the language is very specific, then the use should be allowed. And so the implication is there is no restriction for Code Norris or Track 3, numbers 1 and 3. So for some reason, number 2 has this different language, this commercial language. I submit to the court that 1, that language is limited to Track 2. To do anything else is to try to imply that it applies to 1 or 3, as the appellants have done in their reply brief. That is taking an ambiguity. And if there is an ambiguity, the use of the property has to be allowed. So you cannot take the language from 2 and apply it to 1 or 3. Now, with respect to Section 2 specifically, stating that the commercial use would include home rentals is different, but yet the same idea applies. Somebody coming to stay for a week in a home is using it for a residential purpose.
Okay, well, I'm going to ask you some specific here. Doesn't it say that some lots, designated lots, may be used for commercial purposes?
Yes, that language is in
And
there.
this, we're talking about Section 2, I guess now.
Yes, only Section 2.
Only Section 2. And then it describes commercial purposes as including being rental.
It does say home rental, Your Honor.
So, I mean, that seems to say that at least as to Section 2, under the definition of the restrictions, that renting it home is a commercial purpose.
For certain lots under Section 2, there is the language that says a commercial purpose can be rental of the home.
Okay, so
Does it say it?
but are you saying,
Always a commercial purpose, or can that be a residential and a commercial purpose?
but are you saying then for those lots, they can rent it and it's a commercial purpose, but for the lots that are not the designated lots, they can rent it and it's not commercial purpose?
Well, I think that the language is very odd, and of course, it's odd that it only applies to 1 section out of 3 in the neighborhood, and even more odd that, it arguably only applies to certain lots in that section. But for those lots in the section that don't have the language about the commercial use, then I would submit that it's a residential use because that commercial use provision doesn't apply to those lots.
Doesn't apply to those lots in number 2?
The lots that are not specifically identified to allow this commercial use.
What's the purpose of it? What's the purpose of saying these lots can rent it even though it's a commercial use? If anybody can rent it.
Yeah. Well, I think the term of what is a residential use.
Well,
I mean,
but
somebody
my
could rent a
question
home
to you-
and open a small business in it. That happens every day.
Okay, hold up a second.
Sure.
But it defines commercial purpose in the restriction as being a rental. And says that's allowed as to these designated lots.
For certain lots in Section 2,
it's
that
allowed-
does state.
It's allowed for these designated lots.
That's correct, Your
Under
Honor.
your position, they could rent it, any lot could rent it. So what purpose did that phrase play? What was the purpose of putting it in there?
To specifically identify that any lots, there is other language in the restrictions about rentals and having for rent signs that indicate that rentals are allowed in other sections of the neighborhood.
I'm talking about this Section 2 now.
But this Section 2 specifically does include that language, but there is also language in Section 2 about the type of signage and such is allowed, and it doesn't limit it to specific lots. So it does appear there can be some ambiguity in looking at the restrictions as a whole.
Okay.
So moving on to the nuisance issue. The appellants amended the complaint to present the second amended complaint to the court after the FSD decision came down. So the appellants no longer had a clear path to prohibit short-term rentals under the restrictive covenants, and so instead, nuisance allegations were added to the complaint, really as a mechanism to still try to ban short-term rentals, but under a different legal theory, under a nuisance theory. As the court noted, the sole factual allegations in the second amended complaint as to nuisance are conclusory allegations to all of the defendants and all of the lots at issue in this case. There are not specific allegations as to any particular lot, any time or place. And in fact, the allegations are identical as to each lot, saying that guests who routinely stay at each of Appellee's properties on a short-term basis often host late-night parties, blare loud music at unreasonably loud levels and at unreasonable hours, etc. And as a result of this conclusory language, the appellants seek an injunction against the nuisance, which in this case, the nuisance that they've alleged is essentially the short-term rental, because they have alleged that it's only the short-term rental guests who are doing this. No reference that owners of lots in the property may have their own parties. That would also be a nuisance, but the only allegation here is specific to the short-term renters. Specifically, these conclusory allegations contain no allegations that the appellees themselves are engaged in this activity. It is only that the short-term renters are engaged in these activities. I would point the court to the DuPont Rayon Company versus Roberson case, 12 Tennessee Appellate 261 at page 268 from 1930, as well as the Beeman v. Grooms case, 138 Tennessee 320, 1917. This established Tennessee law provides that the appellees cannot be held liable for nuisances maintained by their tenants at the properties. The nuisance activity, the late night parties or music that is alleged, those are specific acts of those renters and not of the property owner appellees here. While the appellants in reply have stated that the appellees have expressly licensed this activity and that would get them out of the holdings of DuPont and Beeman, I submit to the court that if you take a careful look at the language of the second amended complaint, there is no allegation that the appellees have expressly licensed their tenants to do the acts amounting to the nuisance, the parties, the music. Rather, the precise language in the second amended complaint is that each appellee is allowing the use of their respective property in violation of the restrictions as commercial short-term rental operations. The act of renting, permissible under FSD, is not the act of nuisance that is complained of. The act of nuisance, the parties and the music, and those are actions of renters. And there is no allegation in the second amended complaint that the appellees have authorized or licensed or allowed this activity. And therefore, the appellants have not stated facts that would allow a nuisance claim to survive a Rule 12 motion, and the trial court's order dismissing the nuisance claims should be affirmed. We've talked a lot about FSD and does it apply, does it not apply, but I would like to circle back to the discussion that the short-term rental without more does not prohibit, the use restriction to residential use without more does not prohibit short-term rentals. In the language for Tracts 1 and Tracts 3, we've talked about Tract 2 a lot. Tract 1 and Tract 3 are almost identical to the FSD language. And again, there has to be a specific language to restrict the use in order for the covenants to be held to restrict the use. And the trial court properly examined FSD and determined that there is nothing in the covenants at issue in this case that would restrict short-term rentals. It was appropriate at a motion to dismiss phase, taking, as we do on motions to dismiss, taking the facts alleged as true, that there is nothing to distinguish the covenants at issue from the covenants at issue in FSD. And so for that reason, the trial court's decision should be affirmed and upheld under the FSD precedent. There are two other issues I'd like to address briefly that have been raised by the appellees, and that is related to the fees and costs, both under 20-12-119C, the so-called loser pay statute on motions to dismiss. The appellees submit to the court that they are entitled to an award of attorney's fees and costs in obtaining dismissal of the second amended complaint. While the statute does admittedly contain an exception for good faith, non-frivolous claims filed for the express purpose of modifying existing precedent, the appellees submit to the court that with FSD's binding decision and the binding decisions of DuPont and Beeman, that this was not such a good faith, non-frivolous claim, and that they would be entitled to the mandatory fee award under that section. And likewise, the appellees have requested fees for a frivolous appeal under 27-1-122 to the extent that the appellants are essentially seeking to use a nuisance allegation to obtain the relief that's prohibited by FSD. Thank you.
Thank you. Hear from the appellant rebuttal.
Thank you, Your Honor. Obviously, briefly, on who's creating the nuisance, setting aside, we believe we've properly pled and stated that this property has been provided to these guests. I wouldn't call them tenants because there's no lease or anything like that before the court. That's where we're kind of getting putting the cart before the horse here, because if they want to rely upon that defense, they've got to demonstrate that. They have to put evidence in the record. And that is an affirmative defense. They are saying, taken as true that these nuisances exist, we're not liable. That's an affirmative defense, and they have the burden to plead and prove that. That has not happened here because we are on a 12026. And they can argue that all day long, but it's certainly not, it's just not proper to do that under these circumstances. Again, not to beat that dead horse, but we're talking about a Rule 12 case. We have notice pleading. We have basically placed them on notice. This is, if you take our complaint at face value, which the court must do for purposes of Rule 12, we have alleged this property has been provided to short-term rental guests. And when short-term rental guests go in there, this often happens. That's a nuisance at common law. It's also a nuisance that's restricted by the restrictive covenants on any of these properties.
Did you identify a pattern of a nuisance?
Pardon me, Your Honor?
Did you identify a pattern of nuisance?
Yes, Your Honor. We say that this commonly happens, and it's the late parties.
That's the allegation, but did you actually identify people who are renting on a short-term basis where they actually committed acts of nuisance?
Well, two things I'd say to that is, first, we have to get into discovery to really identify who's been doing what. We don't know who's, until we can engage in discovery, we don't know who's been doing what on these properties. It's worth noting that it doesn't matter under our nuisance theory whether the person is a long-term tenant, short-term tenant, or a resident. But we will obviously have to do discovery on who's been staying there so we can determine, specifically, what nights are causing what activities. But again, that's not the office of a Rule 12 motion. If we can't find the goods after discovery, maybe they'll cook us on Rule 56, but we're not there yet. Our clients are simply asking for their day in court and an opportunity to discovery on these claims. Now, as far as saying this is a frivolous appeal, I like to respectfully represent to the court, we don't file frivolous appeals. And I think the court must acknowledge that this is not a complicated case, but there are certainly weighty issues that I think the court's going to have to wrestle with here. And frankly, I think the court must reverse this ruling, and obviously, if that's the case, we don't even get to the fee-shifting issues. And I think the court accidentally gave me an extra minute first time, so I'll unless there are questions, I'll have a seat.
I hear none.
Okay, thank you very much, Your Honor.
Thank you. Our thanks to counsel for both sides. We appreciate your briefs and your oral argument on this today.